Continuing our discussion of search warrants, State v. Benters presents an interesting issue. In that case, Mr. Benters was charged with various drug offenses stemming from a grow operation that he had at his residence. Part of the search warrant, an essential part of the warrant, dealt with information provided by an informant. The informant was described as a confidential and reliable source of information, and that source told the officer that an indoor marijuana grow operation was located at the subject premises and stated the operation was housed in the main house and other buildings, and the informant knew the name of the subject being Glenn Benters. The trial court granted defendant's motion to suppress, stating that the information provided as to the reliability of the informant was insufficient. The state then appealed it. Court of Appeals stated that the officer described the informant as a confidential and reliable source of information, but did not state on what prior occasions the informant's information had proved reliable, whether the informant had personally witnessed defendant's grow operation or that informant had purchased marijuana from defendant. Although the threshold for establishing an informant's reliability is low, that threshold must be met. The court went on to state an affiance statement that a confidential informant has proven reliable and credible in the past is sufficient to sustain a warrant through probable cause. The court noted information provided by a confidential informant who has not proven to be reliable by providing information which later proved to be truthful or resulting in arrests and convictions in the past lacked sufficient indicia of reliability to establish probable cause for the issuance of a search warrant for the defendant's property. As we noted in McKinney, the language should be, I have received information from an informant who I know to be reliable because he has given me information in the past that has led to numerous arrests and conviction for drug-related crimes. Now, the officer might ask, what happens if this source has not provided reliable information in the past? Then the officer needs to corroborate the key portions of what the informant has provided. The officer needs to press the informant for great detail, which in turn will establish the person's credibility, because no one but a person telling the truth would have that much inside information unless they obtained it firsthand. And again, answering the questions, how does the person know it? Did they buy drugs, therefore making a statement against penal interest? Were they there? How long ago? How do they know this person? Again, there are ways to establish reliability and credibility, but certainly the most common one is, again, having given information in the past leading to arrests and convictions. Another interesting issue arose in this case that was addressed by the court. That is, the detective testified at the motion to suppress hearing that indeed this informant had provided information in the past that led to arrests and convictions, and that he indeed was credible. But the problem becomes, as the court noted, only information presented at the time the warrant was issued can be considered, despite the requesting officer later testifying that he had unintentionally and inadvertently failed to provide information regarding the reliability of the informant in the warrant affidavit. So what do you want to take from this case? When you draft your search warrant, take your time. Put in the key facts. Have someone unfamiliar with the case review it. Make sure your T's are crossed and your I's are dotted. Remember, the court is going to consider what you put in your warrant, not what you could have put in your warrant and later testify to.